you actually had a number of stories this week in the same vein. So I figured we just talk about them all at once. Basically, this is the response from California and New York to the Bruen ruling, to striking down May issue gun carry laws based on subjective standards, and California and New York came up with basically the same law, right? And what happened in those two states?
That's right. Yeah, you sort of had opposite outcomes, I think, in the two states that most people expected to have the heaviest response to Bruen. So as you pointed out, New York's Concealed Carry Improvement Act, they call it, which is just a whole host of different restrictions on the ability of people to get permits. And once they have the permit, it restricts where they can carry. Like for example, all of Times Square is off limits, which I'm sure a lot of people have been following. Well, that law just went into effect Thursday of this week that we're recording. The Gun Owners of America tried to sue to get an injunction on that law, saying it was unconstitutional. And sort of at the last minute, just a few hours before midnight when it was supposed to go into effect, the judge handed out that ruling, and he dismissed the suit on a technicality. Basically, he said that the plaintiffs didn't have standing in that case. And so as a result, that law was allowed to take effect as of September 1st. On the flip side, in California, you had a last minute attempt by legislators there to actually pass a bill that was very, very similar to the one in New York. Same sensitive places restrictions, a whole bunch of restrictions on actually getting a permit. And that one actually failed in the heavily Democratic legislature, which is a very interesting development.
Yeah, kind of surprising outcomes in both situations, sort of last minute drama there. Certainly that ruling from the federal judge in New York was very odd. It found that the plaintiffs didn't have standing, and in large part because the individual plaintiff was too law-abiding.
Yeah,
was kind of the logic there, that he wouldn't break this law.
Right,
is the sort of the argument. So he doesn't have standing to challenge it because he won't be arrested because he'll go out of his way not to break it. Just sort of a roundabout logic to that ruling. And then the judge went, of course, as you looked at in a member's piece for us, the judge went to the merits anyway, and basically said the law was unconstitutional.
Yeah.
Very weird outcome in that case, but foreshadows, as I think you laid out pretty well in that member's piece, that this law is probably not long for this world. I don't know that it's going to survive legal scrutiny for much longer. It's this sort of ruling feels like a bit of a cop-out from that judge.
Yeah.
He didn't want to be the one to block it, even though he clearly thought it was unconstitutional. So he came up with some very odd leaps of logic to deny standing in the case. And then in California, you had the bill fail, which I don't think anyone was really expecting. But it was in there. That was in large part due to how they tried to pass it in this special emergency way, right?
That's right. Yeah. So that the failure of that bill was sort of self-inflicted on behalf of the proponents of this measure. So the way it works in California, you can attach what's called an urgency clause to a bill. And when you do that, whenever you pass, goes into effect immediately rather than 30 days, or in California's case, the following year is when it would normally go into effect. But by doing so, you up the ante in terms of how many votes you need to get to pass a bill. So instead of a simple majority, like a typical piece of legislation, you now have to get a 2/3 majority, a supermajority, in order to pass. And they weren't able to get the supermajority. They fell short by 2 votes because at least one Democratic legislator voted no, and several just sat out the vote because it was a pretty controversial piece of legislation. And as a result, they fell short.
Yeah, and they've ran up against opposition from the California State Sheriff's Association as well, which is a pretty political, powerful political force in the state when it comes to gun carry issues. They're the ones who actually issue the permits in California. So, they came out in full force against this bill and seem to have succeeded in blocking it for now. I think the sponsor said he'll bring it back up in the December session that they have, but you actually there was a call from the gun control advocates for the governor to make a special session, right? And you got a response from his office, didn't you?
Yeah, that's right. So obviously this was a big bill that had the full backing of pretty much every single national gun control group. But
yeah,
in particular,
they helped write these bills. So.
That's right. And in particular, you had organizations like Everytown and Moms Demand Action. Immediately, they put out press releases demanding a special session. They basically accused the state legislature there in California of not having the courage to get this bill done. And so they said, Gavin Newsom, you're a supporter of this bill. You take it into your own hands, call a special session and get this done. And so I reached out to the governor's office and I said, hey, any plans to call a special session? And they didn't give me a direct answer, but they essentially, let me see if I can find the quote here. Essentially, they said that priority number one is in December, here we go. I guess last night's vote was a grave disappointment. Getting a similar bill back to the governor's desk should be the first order of business in the next legislative session, and the governor looks forward to signing an urgency measure as soon as possible. No commitment to calling a special session there. He's kind of saying, we'll see what happens next session.
Yeah, the key words are next session. I think that this was more of the Attorney General's push. He was actually out lobbying on the floor trying to get those last couple of votes, and it didn't go his way. So the governor seems to have taken a little bit more of a backseat approach to this whole thing. I think that does show some of the political limits of these responses that you're seeing in California and New Jersey. New York, although New Jersey too. But mainly those two states have been at the forefront of how to push back after the Bruen ruling, but they're doing it in a way that's like they're not going for gray areas here with most of this stuff. They're just sort of explicitly passing laws that the Supreme Court said are not going to be constitutional under the Second Amendment. These sensitive places restrictions, the court talked about this at length in Bruen and said, yes, sensitive places are an area where you can restrict gun carry. But you can't just make it the whole island of Manhattan, was the quote in the majority opinion in Bruen. And so, they haven't technically done that, but they've come as close as you can without technically doing that. And I don't think it's going to, last. I mean, the same thing they've doubled down, both of these states, on the good moral character clause. They're now requiring people in New York to submit their social media history. The mayor of New York is talking about sending the police to every applicant's home to interview their neighbors. These things are all in service to a completely subjective standard of who has good moral character or not. And that's indistinguishable from what was struck down in Bruen, which was this good reason clause. You have to have what government officials find to be a good reason to carry a gun, and they can deny you if they don't feel like you have a good reason. It's not based on any sort of objective standard. Right. It's just based on their feels, essentially. Yeah. And that's exactly what the good moral character clause is as well. So, they're not really trying to push the realistic limits of Bruen. They're just going straight past them. Right. It seems like, and hitting, at least to me, I don't know.
To your point, hitting on things that the justices explicitly laid out in the Bruen ruling, which is interesting. And Judge Setterby said as much in the lawsuit that he ended up dismissing. As you said, there was that joining analysis. He still analyzed the bill on the merits anyway. But he said as much. He literally said that the good moral character requirement, it does not remove the open-ended discretion that the Supreme Court said was unconstitutional in relation to, proper cause or good cause that these previous states used to have on the books. So he's literally saying, hey, the Supreme Court said this was no good. This meets the criteria that they said was not going to fly. So had there been standing here, this is an unconstitutional statute.
Yeah, he also kind of lays out, I think, what he views as a person who would have standing, which is, he goes through a whole list at the end of his ruling of people who, would be negatively affected by this new permit system in New York. And so it's almost like he was telling the plaintiffs or the gun rights groups who are involved in this case to go and find somebody like this to bring a case. it's pretty odd. It's a pretty odd opinion. But I mean, after all that, you'd think like, why did he go through jump through these hoops to deny standing and then immediately turn around and say, this law is clearly unconstitutional. And if you just challenged it with this person, this kind of person, someone who works late at night in the city was one of his examples, or an elderly person,
right?
That, you would win your cases. That's the feeling you get reading his opinion. It's interesting too, is because it's another one of these post-Bruen opinions that comes down against, these gun control laws, even though this one technically was dismissed. The merits were completely against what New York is trying to do. And that's, there have been very few exceptions so far in the federal courts at the lower levels to that trend. We just saw another one this week where in Colorado, a locality, Boulder County, which you wrote about, had their assault weapons ban, their AR-15 ban, blocked by a federal judge. And this is the second federal judge, a different judge than Superior, Colorado, a little while back, which we wrote about as well. And they're both judges who are appointed by Democratic presidents.
That's right.
Too. I think that's significant as well. The only notable exception so far that I've seen, and obviously you have the 18 to 21-year-old gun carry provisions in Texas be blocked as well in a post-Bruen reasoning, which we wrote about. And then the only real exception to this so far that I can think of is the gun tax and insurance requirement in San Jose, right? Where a federal judge, using Bruen reasoning, upheld that regulation.
Yeah, said surety laws were an analog or something like that. Yeah. But
so far, I mean, even at the lower levels, where I think most gun rights advocates are the least trustful of the lower courts, they've really been going towards this point of view that Bruen does restrict a lot of these kinds of laws, that they aren't viable anymore after that precedent set by the Supreme Court. So, this was another one that's in that vein.
And I think that's an interesting factor to look for going forward with California when they do ultimately return with this bill. Does that tip their rationale at all? There's some reporting going on about some of the discussion that was happening on the assembly floor while this bill was being debated, where some of the Democratic legislators that were trying to be whipped in support of this bill were asking questions of the sponsor, like, is this constitutional? And he couldn't answer. And so that was, at least some outlets are reporting, that was some of the rationale for why certain Democratic legislators wouldn't vote for this bill. And the more rulings you have that lay out the reasoning that, hey, this isn't going to fly in the courts, does that maybe change what they do going forward? I don't know. California likes to be very aggressive with these gun control legislation or these gun control bills. But at the same time, are they going to pass something knowing it's going to get struck down?
Yeah, it's interesting because certainly the justifications that you've seen from New York and California, the people who are supportive of these new laws, these new restrictions, are claiming that they are in line with Bruen, despite everything we just talked about. So they are selling these as like, this is what we can do inside of Bruen. This is what we've determined is constitutional. And, I don't know that they're getting the same kind of uptake as they would like, because again, the California State Sheriff's Association pointed out that they don't think this is constitutional, that it's not only unlikely to help public safety, because one of their main points was that you're trying to put further restrictions on people who historically have had the lowest crime rate in the country. Concealed carry permit holders commit crimes at a lower rate than even the police do in Texas and Florida, where they release data for crime committed by permit holders. And so that was a big part of the reasoning. But the other part was like, so even though it's not going to have an effect, a real effect on reducing crime, it's also likely going to get struck down by the courts, and you're just wasting a lot of money and resources in doing this. And I'm sure that the other thing about in California is a lot of those sheriff's deputies probably have concealed carry licenses because those are the people most likely to get them in the old shall issue or the old may issue system. So a lot of the people who have permits in California, you could see this in the leak, right? The permit data that we reported on a while back. A lot of the people who were included in that leak are either, well-off celebrity types or they're law enforcement and judges. So those people would be directly affected by this new law the most because they're the ones who actually have permits right now.
Right.
So, changing, basically eliminating where they can legally carry a gun, because one of the big and under-talked about aspects of this New York, California law is that it flips the presumption of where you can legally carry a gun on its head. In every other state, you can carry in a publicly accessible area, including a business, if they don't post a sign that says no guns allowed, right? Under these bills, and even in those circumstances, usually it might not even be an actual crime to carry there as long as you leave unasked. But in some states, it is a crime. It's usually a misdemeanor. But in New York and California, if these laws go through, and it has now in New York, anywhere that's private property, any business is off limits to carry in by default and has to post a sign to tell you that you can carry there. And so this makes it, in practice, likely that the vast majority of the state will be off limits to legally carrying a gun. So that's another thing that these sheriffs, these officers in California who probably have permits to carry when they're off duty, or their family members or so forth, their realistic areas they will be able to carry under this bill have been massively shrunk down.
It is an interesting irony, isn't it? The fact that supposedly after the Supreme Court rules that there's a right to bear arms, suddenly your options for carrying are far more limited than under the old restricted unconstitutional standard. Yeah. That's kind of an interesting dynamic.
Yeah, that's another thing that at the end of the day that I think is just going to doom these laws. I don't think that the Supreme Court is just going to allow this to happen. Their whole point was that this is a protected right. It's not a second-class right. You can't just deny this arbitrarily. So I don't think that they're going to allow a state to exist where it's actually harder to legally carry a gun than before their ruling that was supposed to be about how it's a right you can't just infringe on. And so, at the end of the day, there's plenty of arguments, and we've gone over them in the past about how this is all going to play out. Certainly, I think it's likely the Supreme Court will have to get involved at some point. Although, like we just talked about, the lower courts do seem to be paying more attention to what the court had said in Bruin. They're not finding as many ways around this new standard as they did with the old standard in Heller. But the argument against the court doing anything is that it took them so long between Heller and Bruin to do anything that maybe they do something about it, but it will be another decade before that happens, and that's effectively they might as well not be doing anything.
Right.
But and look, that's not an unfair argument based off the last 12 years, but this court just took up 2 cases in a row that were gun cases. The first one did get mooted out of New York, but then they immediately took up another one. And it doesn't seem like the court, with the makeup the way it is now, is just going to allow this New York and California to completely rebuke them in extremely transparent ways. It will be harder to legally carry a gun in New York now than it was before Bruin. And right. I don't know that the court is going to allow that to stand.